This is Mike Franklin, the property tax guy, and today I'm going to talk about my continuing efforts to require the New York State Unified Court System to allow small claims assessment review hearings to be recorded. My position is that there's absolutely no reason why these hearings can't be recorded, and it's important for the public to know what goes on in these hearings for educational purposes, if they need to challenge their assessment, but also to see how their public officials are handling their business, particularly the assessor. My experience with assessors in the 36 or 37 counties that I've participated in these cases in is that there can be, there are good assessors out there, but there could be issues with laziness, incompetence, sometimes outright fraud. I've seen a very large percentage of my cases are from people buying second homes, and they're not from the area, and the assessors like to pin the purchase price on these people. They like to pin sales on people they perceive to be rich and take it easy on their local cronies. And I've actually seen, town boards that are basically controlling the assessor to, to assess things the way they want them to be assessed. And I think that there needs to be transparency. And if you record a small claims assessment review hearing, you can see exactly how an assessor operates. And I'll tell you, if they are recorded, how these hearings go will be very different. The assessor will behave differently. The assessor may be more likely to settle the cases before going because they know that they're wrong. Because when an assessor illegally assesses the property, pins a purchase price when they're not supposed to, there's no penalties for them violating the law. The worst case scenario is that the hearing officer puts the fixes it, and so so they're, if they think people aren't looking, they will do that. But if these things are recorded and it's demonstrated repeatedly that that's what they're doing, so something may be done about it. It's just improper. I tell you, just when you've done this stuff in 36, 37 counties, just when you think you've seen it all, you haven't seen anything. I saw one case where the assessor was the son-in-law of the supervisor. The guy had no assessment valuation experience. He worked at a jail, and so it's crazy. So some assessors are independent from the town board, and some of them are puppets of the town board, and some of them can be quite abusive to the taxpayer. And with an assessor, I expect them to respond to taxpayers' concerns promptly, and to look into their concerns in good faith, and either make an adjustment or politely point them to their appeal options. But when people ask for data, they should provide it. Routinely, they do not. They evade and they delay New York State FOIL. And they do that because there's no penalty for evading FOIL either, really. And so they know that they can get away with this stuff. There's just no teeth in the law. So, in order to force them to comply, you have to be quite persistent. And of course, I'm quite persistent. But anyway, back to recording the assessment hearings. The court does not want these hearings recorded because the court doesn't want to be accountable to the public. They want these things. In my opinion, most of these administrative judges think that small claims assessment review is beneath them. It's bother for them. They're making their 250 grand and pensions and benefits and all this stuff, and really my experience is that they can't be bothered with it, and so they're trying to minimize the amount of work involved. So they just want to shut everything down. You can't record it because they don't want to hear it, and but the thing is, it's inappropriate, and they're citing the law, saying you can't record when the law says nothing of the sort. And I'm going to show you what it is that I'm talking about. So, for example, there's a small claims assessment review hearing officer's manual. It's an 18-page pamphlet that trains the assessors on how to behave and how to conduct a small claims assessment review hearing. And in that manual, it tells them that the hearings cannot be recorded, and cites Real Property Tax Law 735. Well, Real Property Tax Law 735 says nothing of the sort, and that's just what they want it to be. So the courts are creating their own legislation; they're creating their own law where there is no law, and I think it's pretty inappropriate. So I'm going to I'm going to share the screen with you. So broadcast. I paused there for a second because I thought the thing wasn't recording and I was just talking to myself. So here's the law. Real Property Tax Law, Section 735, Laws of New York. No transcript of testimony shall be made of a small claims assessment review hearing. The hearing officer's decision of a petition for small claims assessment review shall not constitute precedent for any purpose or proceeding involving the parties or any other person or persons except as provided in Section 739. Section 739 just pertains to, just so you know what 739 is, it's a prohibition against, sorry about that, change in assessment following decision in small claims. So in other words, if you get a reduction in your assessment, the next year the assessor cannot change that assessment unless there's been a townwide reval, or you have pulled the building permit, made changes to the property, and other details that are so 739 has nothing to do with video recording properties, but since it talked about it, I want to make certain that you knew that it had nothing to do with this. But anyway, basically it says determination, not precedent. So small claims assessment review hearings are decided based on determination. They're not based on precedent or case law. So there's no need for case law. There's no need for transcripts. So there's no transcripts in these hearings. So what the court is suggesting is that a video recording is a transcript. And so let me help them out with what a transcript is. Trans as in translate, script as in scribe, as in writing. Transcript, translation to writing. And typically, according to Black's law, a transcript, in the context of court proceedings, is done by a court reporter. So it's a translation to writing by a court reporter. A video is not a translation to writing by a court reporter. I am not a court reporter. And so let me show you the training materials and what they say. It says here, a hearing officer may take notes, but no recording devices of any kind are allowed by anyone, nor are court reporters allowed to transcribe the proceeding. And they cite Section 735. Well, where in Section 735 does it say anything of that sort? It doesn't. And these are training materials. These are not the law. And so the court writes this in there because they don't want these things to be recorded for their own purposes. It's essentially self-dealing. It's for their own convenience. It's got nothing to do with the law. And also, as far as I'm concerned, denying an application for audiovisual request is an application by the media, and I am a member of the media. Every person in this country is potentially a member of the media, or of the press, rather, and we have, every person in this country has freedom of press, and I regularly disseminate assessment matters to the public. That's press, and so I am legitimate press, even though there really is no such thing as legitimate press, because all press is legitimate. Every person in this country has First Amendment press rights. So if this court is going to limit our freedom of press, they have to come up with a reason for doing so. And they haven't been able to do that. I submitted an application to one hearing officer, and his response was denied. I pressed him on it, And he said Section 735 says you can't record it. And so that's not a legitimate response. And that's it. It's you can't record it because he said so. I had another hearing officer said that our training says that we can't allow recording. Well, that's not the law. And so when I have requested cases, for example, in Broome County, they then rescheduled the hearing to be in a courtroom, and I'm surrounded by court police to make certain I don't record. I had one court cop hovering over to me to make certain I wasn't recording. Same thing happened in Jefferson County. 3 court cops. There's more out in the hallway, and with one hovering over me to make certain I don't record for an assessment hearing, for God's sake. So they're tying up an entire courtroom, 3 cops, the judge, for what? To make certain you don't to make certain that they're not accountable to the public. It's outrageous. So anyway, so I'm collecting the responses from all these hearing officers. I have requested from the 4th Judicial District. I appealed to the administrative judge of the 4th Judicial District. They provided me with no explanation. I appealed to the chief administrative judge for the entire state. Nothing. They suggested that they can't give me legal advice, and nor did I ask them for it. But they gave me no justification. And so and I went through it with the 6th Judicial District, and they cite the Civil Rights Law 52. Apparently, civil rights laws protect the censors from being accountable to the public and hearing officers as well, which is utter nonsense. Section 735 doesn't pertain. They cited the 131.1 rules of the administrative judge, which are policies of the court for court officials. The public is not subject to the policies of the court, and policies do not trump the First Amendment to the Constitution. So after I collect these responses from all these hearing officers from the 3rd, 4th, 5th, and 6th judicial districts, I'm appealing to each one of the administrative judges, and I'm appealing to the chief administrative judge. And if I'm denied by all of them, I intend to sue them. I think initially in state court, which is kind of an exercise in futility, because I'm suing the court. So the court is the judge over my suing the court. It's absurd, but I think I'm going to do it anyway to force a response. Have them explain to us, to the public, in writing, that a transcript, that a video is a transcript. I want to see them explain that in writing, that a video is a transcript. I can't wait. I can't wait for them to tell me that civil rights laws protect assessors from being accountable to the public. I want to see them tell us that the rules of the administrative judge trump the First Amendment to the Constitution. I can't wait. And, I expect to have some sort of disingenuous response, but you got to give them the opportunity to do the right thing, because I've been surprised in the past they have done the right thing. So I want to see what it is that they do. And if that doesn't work, I intend to file a federal 1983 civil rights lawsuit. And I'm going to argue that they are unjustifiably restricting my First Amendment freedom of press. And I just don't think that they have the right to do that. Unless New York is seceding from the Union, the Constitution is the law of the land. It is the supreme law of the land. And they have no justification to limit my recording SCAR hearings. And again, Board of Assessment Review hearings are routinely live streamed on YouTube, so I don't see what the difference is. So I just don't think that they have an argument, and I'm going to push it. And I can't wait to see what their response is. This is Mike Franklin, the property tax guy.